You probably never expected to hear this on the news, but here we are. President Trump is now using affirmative action principles to defend gun owners across America. Yes, that's exactly what's happening right now. The Department of Justice has just filed a legal action that has never been attempted before in our nation's history, and it's about to turn the entire gun rights conversation completely upside down. Right now, I'm going to walk you through the most important ways Trump's administration is taking action against states that have been stepping on your Second Amendment freedoms for many, many years. And I'm telling you, that last point is going to be absolutely revolutionary. You definitely don't want to miss what's about to happen here. So let's dive right in. For the very first time in American history, the Department of Justice is using civil rights discrimination laws to challenge states that put restrictions on gun ownership. Now, you might be scratching your head and wondering how civil rights laws connect to firearms. Well, this is where things get really fascinating. The legal team working for Trump is using a specific law called 34 U.S. Code 12, 6001. This particular law was actually written back in the 1960s to stop corrupt police departments from trampling on people's constitutional rights. This is the exact same legislation that helped break down discriminatory practices within law enforcement agencies. This is the very same law that helped protect people's voting rights. And now, this same law is being applied to protect your right to own and carry firearms. Just take a moment to think about what this really means. The federal government is now declaring that when someone is denied their Second Amendment rights, it's just as serious as denying them any other protection guaranteed by the Constitution. And here's exactly why this is such a big deal. When you start treating gun rights the same way you treat civil rights, everything about the legal situation changes completely. California has been playing games with gun owners for years and years, using bureaucracy and endless paperwork to make things nearly impossible. The approval rate for permits in some areas is actually lower than the acceptance rate at Ivy League universities. Now let's talk about the next shocking piece of information, and this is where the statistics become absolutely mind-boggling. We're looking at numbers here that are actually worse than trying to get admitted to Harvard University. Between January of 2024 and March 2025, Los Angeles County received a total of 3,982 applications from people wanting concealed carry permits. Now, before I tell you how many of those applications were actually approved, let me give you some background information so you understand just how crazy this really is. Harvard University has an acceptance rate of around 3.4%. Stanford University accepts about 3.7% of applicants. These are considered the most difficult schools to get into anywhere in America. So go ahead and take a guess right now about how many concealed carry permits Los Angeles County actually approved out of those nearly 4,000 applications. Just think about what number you'd expect. Are you ready for this answer? The answer is 2. That's not a mistake or a typo. Just 2 permits were approved out of 3,982 applications. That comes out to an approval rate of just 0.05%. You actually have a better statistical chance of being struck by lightning twice in your lifetime than getting approved for a concealed carry permit in Los Angeles County. Some people who applied have been waiting for more than 1,200 days. That's more than 3 whole years just to get any kind of response at all. But here's the part that makes this situation even more outrageous and frustrating. California actually has its own state laws on the books that are specifically designed to prevent exactly this kind of situation from happening. Their penal code very clearly states that initial determinations are supposed to be made within 90 days, and the final approval or denial absolutely must happen within 120 days at the maximum. This isn't just guesswork or speculation anymore. This is solid, hard evidence of systematic discrimination happening right under everyone's noses. Here's something else that completely flies under the radar, but it's actually costing gun owners thousands and thousands of dollars. You see, when California forces you to wait for years and years to get a permit, they're not just wasting your time and making you frustrated. Every single time you have to renew your application because it expired while you were still waiting, that's another fee you have to pay. Every single time you have to retake a training course because your certification became too old while you were waiting around, that's more money coming out of your pocket. Background check fees, fingerprinting fees, processing fees that you're forced to pay over and over and over again while they drag their feet and delay everything. Some people who applied in California have already spent more than $2,500 just trying to get through this process, and they still don't have their permits in hand. This is basically a poll tax on your constitutional rights. And yes, that's the same poll tax idea that was ruled unconstitutional many decades ago when southern states tried to charge people money just to vote in elections. The average person applying is spending somewhere between $800 and $1,200 over the course of their waiting time, paying for renewals and recertifications that would never be necessary if the county just processed applications on time like they're supposed to. Now we need to discuss something that's probably going to make you pretty angry when you hear it. This problem isn't something new that just started recently. The Obama administration knew all about California's permit schemes and problems. The Biden administration knew about it too. State legislators knew what was happening. Federal judges knew. And absolutely nobody did a single thing about it for more than a decade. In fact, internal memos from the Department of Justice during the Obama years show that they were fully aware of excessive wait times in multiple California counties going back as far as 2014. They had all the data sitting right there. They had the complaints from citizens. And they made the choice to look the other way and ignore it. Why would they do that? Because going after blue states for gun rights violations simply wasn't politically convenient for them. The Department of Justice under previous administrations would jump into action immediately for other types of civil rights cases. They would investigate police departments when there were problems. They would file lawsuits over voting access issues. They would file legal briefs in discrimination cases. But when it came to anything related to the Second Amendment, suddenly they had other priorities they said were more important. They would only get involved if a case was already making its way through the court system on its own. And even then, they would often file legal documents on the side that opposed gun rights instead of supporting them. The Department of Justice defended the handgun ban in Washington, D.C. They defended gun restrictions in Chicago. For many years, gun owners were completely on their own, forced to fight expensive legal battles against states that had unlimited taxpayer-funded legal teams working against them. During all those years of inaction and looking the other way, thousands and thousands of applications were either denied outright or delayed indefinitely. And here we are at the final and absolutely most important point of all. This is the complete game changer that's going to create ripple effects across every single restrictive state in America. If Trump's Department of Justice wins this case and legal experts are saying they have an incredibly strong chance of winning, it doesn't just fix California's permit problem. It creates binding legal precedent that makes these delay tactics illegal everywhere across the country. New York, New Jersey, Maryland, Hawaii, Massachusetts, Connecticut, and every other state that's been playing these games is going to be put on notice immediately. Any jurisdiction anywhere with wait times that exceed reasonable time periods, any county anywhere with suspiciously low approval rates, any state using red tape and bureaucracy to functionally ban gun ownership, they're all going to be vulnerable to the exact same type of lawsuit. Once a federal court makes a ruling that these delays actually constitute civil rights violations, it's not just about concealed carry permits anymore. It applies to any gun-related licensing or registration scheme that creates unreasonable barriers for law-abiding citizens. All of it becomes challengeable under the same legal theory and approach. The financial risk alone is going to make states think twice before continuing these practices. Civil rights violation cases come with very significant penalties and legal fees that have to be paid. So even jurisdictions that aren't directly sued themselves are going to start reforming their processes just to avoid being the next target. This is what real accountability actually looks like in action. Not accountability to politicians or to bureaucrats, but accountability to you and your constitutional rights as an American citizen. This entire situation represents a fundamental shift in how the federal government approaches Second Amendment protections. For far too long, law-abiding citizens who simply wanted to exercise their constitutional rights have been treated like criminals just for trying to navigate an impossible system. The statistics we're seeing out of Los Angeles County aren't just numbers on a page. They represent real people whose lives have been affected. These are people who might be small business owners worried about protecting themselves and their livelihoods. These are people who might be senior citizens concerned about their safety in their own neighborhoods. These are people who followed every rule, filled out every form correctly, paid every fee, and still got stonewalled by the system. What makes this legal action so powerful is that it's using the government's own tools against overreaching state policies. The same laws that were designed to protect citizens from discrimination are now being applied to protect Second Amendment rights. This isn't about creating new laws or new interpretations. This is about applying existing civil rights protections in a fair and equal manner. When the federal government recognizes that denying someone their Second Amendment rights is a form of discrimination, it changes the entire landscape of how these cases will be handled going forward. The implications go far beyond just California. Every state that has implemented similar schemes needs to pay attention right now. The days of hiding behind bureaucratic procedures and claiming processing delays are just administrative issues are coming to an end. When wait times exceed 3 years and approval rates drop to 0.05%, that's not administration, that's obstruction. That's not regulation, that's prohibition by another name. And now there's finally a Department of Justice willing to call it what it really is. The courage it takes to file this kind of lawsuit shouldn't be underestimated either. This isn't the politically safe route. This isn't the path that gets praised by mainstream media outlets. But it is the right thing to do when citizens are being systematically denied their constitutional rights. Previous administrations had all the same information, all the same data, all the same evidence, and they chose inaction. They chose political convenience over constitutional duty. That era appears to be over. Looking at this situation, it's important to understand what winning this case would mean for ordinary Americans in every state. It would mean that the right to keep and bear arms gets the same legal protection as every other constitutional right. It would mean that states can't use administrative tactics to functionally eliminate rights they disagree with politically. It would mean that citizens have recourse when their government refuses to follow its own laws and timelines. Most importantly, it would mean that the Constitution actually means what it says, and that those rights are enforceable and protected. The message being sent here is crystal clear. If you're a state or county that's been using delay tactics, unreasonable requirements, or bureaucratic obstacles to prevent law-abiding citizens from exercising their Second Amendment rights, your time is up. The federal government is watching, the legal framework is in place, and there's now a Department of Justice willing to take action. This isn't a threat, it's a promise of accountability. This is about ensuring that every American, regardless of which state they live in, has equal access to their constitutional rights without facing discrimination or impossible barriers. So if you believe that Trump's Department of Justice can actually pull this off and permanently change gun rights across America, go ahead and drop a comment below and let me know which state you think should be the next one investigated and sued. And if you want to stay informed about stories like this that the mainstream media won't bother covering, make sure you hit that subscribe button right now so you don't miss a single update. The fight for constitutional rights is far from over, but this represents a major turning point that could reshape the entire conversation for decades to come. I'll see you in the next one where we'll continue following this historic case and its nationwide impact.